somebody has reached or not.
Dulos, just
Yeah,
one
I'm
thing.
checking. Yep.
ना आईफोन का तुम ब्लूटूथ ऑफ कर देना, बहुत बार उस पे कनेक्ट हो जाता है तुम्हारा.
मैं कर दिया, मैंने already कर दिया. Okay, and we are. Are we live? I'm just checking on phone whether it's we are live or not. Yeah, we are live. That's awesome, and we have like a couple of people already over there. Hi, good morning, everybody. It's been a while since we last spoke. We wanted to do it every week, but then, yeah, work happens. So, anyways, thank you very much for joining us today. We have yet another exciting session planned with somebody outside Pushkar, so I can pull some more legs, right? So we have Prakriti today, and from JSA. She is expert in M&A and acquisitions and mergers and sales of your D2C brand. To be very clear, precise, right? So why we thought of this topic is basically that we have done about what 4 or 5 webinars so far. Been discussing with a lot of founders. Every event attracts about 100 people on and offline. Then we get a lot of queries, and one of the most asked question was due diligence and how do we handle that sales process altogether, right? So we tried addressing the due diligence bit, the last one, but the merchant acquisition and the loopholes around it and the legalities of it is something beyond our purview or our expertise, right? So we just thought we'll rope in an expert over here. So if you have Prakriti, as I introduced, she is an expert in this. She's been working in this field for about 12 years. She has helped us as well as a lot of other startups, a lot of other agencies and startups and all to get acquired and make mullahs, right? So she's a money maker. So we'll sort of introduce. We'll have got some sets of questions as always, which we'll ask Prakriti, which I'm sure will be very insightful for all of you. And after that, in between or anytime in between, you can actually on the comment box you can raise a question, and if it's relevant, we will definitely take the question then. Otherwise, we will keep it for the end, and we'll address all those questions in the end, and then we'll have an insightful session at by the 40-45 minutes. That's our expectation, right? So Pushkar, shall we start?
Yeah, good to go.
I'm not introducing you. You are the eminent personality, right? So you're the one who's bringing all the people in here. So you can just go ahead and ask the questions probably.
Yeah. So good to go, Dulos.
So yeah. So over to you, Pushkar.
Perfect. So thanks for joining us, Prakriti. Always a pleasure.
Thanks, Dolos. Thanks, Pushkar.
Awesome. So one thing what we have seen is, like, say you are a D2C brand. Now you want to raise capital, or you want to sell it to an aggregator. Now you have the first round of conversation. You have negotiations. You agree on a valuation,
Correct.
and then the seller, the buyer, or the fund, like depends upon whom you negotiating with. They give you a term sheet or an LOI. Now, what exactly is that? What do we? So I know what it means, but letter of intent. But what does that signify?
Right. So, firstly, thanks for the warm welcome, Dulos and Pushkar. So, speaking about any M&A transaction, or even let's say if someone is doing a fundraise and is raising fund from a venture capital, what typically happens is that parties will initially look at the books of account, the financial, etc., and they will agree on, let's say, whatever is the multiple being offered or whatever is the valuation being offered. So your LOI or a term sheet, as we call it, that is more like an indication of an interest by a particular buyer or an investor in the company. So an LOI is merely supposed to cover essentially that what the valuation is, what the deal contours are. For example, let's say, is it 100% sale that is going to happen of the D2C brand or any other startup, or is it going to be just a fundraise where the investor is going to put in money into the company? So whatever are the key contours of the deal, that is what gets captured as part of the term sheet or an LOI, and what is the valuation that is being offered. And plus, if in addition to that, if there is any other key terms that the investor and the founders have agreed to, that gets captured as part of the LOI. Typically, you would see an LOI is really non-binding in nature because, at that point in time, basis whatever financial, etc., business model, what the founders or the startups have provided to the investor, they have looked at that, they have given their indication of interest, but they would like to conduct, let's say, a detailed due diligence to see whether or not this company is viable for investment. So that's the reason why this is kept as a non-binding, which means which means that it's not enforceable against the investor or the founder, because parties need to agree on the details of the detail of the deal that is going to be done. So that's the reason why it's non-binding in nature, except for a few provisions like confidentiality, dispute resolution, etc., which becomes binding.
Okay, brilliant. And what we have
Before,
also,
sorry, Bashka, before you jump into the next question, folks, just let us know on the chat box if you're able to see us, because I think there was a black dark screen in between, right? If you're unable to see us, just let us know on the chat box, please. Or if you're unable to hear us, maybe it's a slight delay. Yeah, but
okay. So what I was saying is, like, whenever we see like a LOI between a buyer and a seller, or a fund and a startup, now there are always a lot of due diligence clause, like the buyer or the fund will do legal diligence and then a financial diligence. So why do they insist on a legal diligence? What exactly is a legal due diligence? What happens in that?
Right. So essentially, Pushkar, there are two, three categories of diligence that any typical investor or a buyer would like to do. One of them, which is obviously something in my domain, is the legal diligence. Other than the legal diligence, there would be a financial diligence, which is basically means that the investor is going to look at the books of accounts of the company, how the company has performed in past, what are the quality of earnings, etc. So that's on the financial side, and of course, depending on the size of company, they would also do like a tax diligence to see what are the direct tax and indirect tax kind of implications. But sticking to the topic for today about the legal diligence, typically the reason for doing legal diligence is like any other audit, right? To see that in a particular company, what are the compliances that has been there. For example, if the company is required to maintain corporate secretarial minutes, then what are the corporate secretarial minutes that have been maintained. If there is a particular contract that the company execute, let's say it's a manufacturing company, it would have certain kind of contracts which is there. So what are the kind of contracts that the company has executed? Then you will also discuss about the financing facilities, for example, the loans that the company may have obtained. You would want to see what are the specific lender terms in that. So for example, if there is a specific loan agreement that is obtained, many times you would see in the typical lending documents there would be things about change of control. So if it's 100% buyout, you might need to either get the approval of the lender, or you might need to repay that loan as part of the transaction so that the lender doesn't call it a default. So you would look at that. Then your typical HR issues. If it's a startup in the manufacturing, then there could be workers that are working in the factory. So HR related issues in relation to that. If it's, let's say, an IT startup, in that particular case, again, what are the kind of provident funds, gratuities, your state insurances that are being paid. So the investor would look at all of these compliances. Any specific brands, the intellectual property also becomes important, whether the IP is registered, not registered, the trademark that is being used by the startup, whether it's registered. If it's a patentable business, then has it been patented or not? So those are the kind of things a typical investor would look at. The idea of doing a due diligence is threefold. One is that to see if everything from a compliance perspective is kosher in the company. So that is the first idea of doing a diligence. Second is to see that let's say if the buyer believes that the business is such that I am going to require the intervention of the founder for a particular period, because there could be certain things in the business that require transitioning to be done. So even to determine the structure for the transaction, the buyer would want to do a due diligence. Then again, if there are any specific obligations of the company that the company has not in due course discharged, let's say there are outstanding tax notices, the buyer would want that this is prior to the time I have come into this company, and I don't want to take the burden of your past tax liability, so I want you to specifically indemnify me for this. And I will speak about indemnity in later part of this. But there could be obligations that you identify, which the investor does not want to carry forward with themselves, and they want the promoters to be liable for that. So that again is one of the key reasons why a due diligence is run.
Okay, thanks. Brilliant answer. So, how, like what you have said is, now in any transaction, there are two parties, buyers and sellers. Buyers will have their legal team, sellers will have their lawyers, right?
Right, right.
And then buyers' lawyers will try to protect the buyer's interest, saying, all right,
That's
there could be like 20 different things you should be aware of. We just want to be sure like all these boxes are checked. Now you spoke about maybe 10, 15 of those things.
Right.
Now, what in your experience are the five most or maybe three most critical clause that could be a deal breaker for the transaction, like that the buyer's lawyers always insist?
Right. Pushkar, I think there is no tailored answer for this. To be honest, it will completely be dependent on the structure that we are doing. So, let me speak a little about the kind of structures that we see for a typical D2C brand, right?
Mhm.
So, I think one of the structures that one would see is that it's a 100% buyout, which means that one of the aggregators or one of the investors is just going to buy out the entire company. The founder has done their bits of building the brand, etc., and now the aggregator or the investor really wants to buy that out. So that is a 100% sale transaction. In a 100% sale transaction, what is it that a founder is going to look at? The founder is going to look at that, what is the maximum value that I can get out of this transaction, because I'm just selling the business, and I'm going to just go on and not do this business going forward. So in a 100% transaction, typically what your deal construct would look like, that there is going to be a sale and purchase of shares. There is a particular consideration that you're going to get. What one needs to see is also that, from the due diligence, is there anything that has come up which requires any deduction in the valuation? Because that's what our investor is going to insist on. That I had thought that your company is worth so much, but when I have diligence to your company, I realized that, let's say I'm going to deduct X amount from the initial consideration I had proposed for you. So there could be one of those kind of conditions that come in. Then, so agreeing on the valuation becomes important basis the findings from the due diligence. Then after the evaluation is done, then what are the kind of CPs that come in the document? By CPs, I mean condition precedents. Because what might happen in a 100% deal is that after the diligence has been done, the buyer might identify that there are XYZ things in the company that are not right from, let's say, from a legal perspective, or certain contracts that are not robust enough. So your investor may want that you correct all of this before I invest into this company, because after a 100% deal, you're not going to be involved in the company, and I don't want to take on the baggage of clearing up everything that you have done in past. So again, the CPs become very, very important from a transaction perspective, because till the time the CPs are completed, the transaction will not close, which means you will not get the money. So I think what are the kind of CPs you are agreeing to is something that becomes very critical, because some of the things you might feel particularly that, I don't need to complete this, the buyer can do this because this is, ordinary course of business. So in that particular case, the CPs become important. Then comes your reps and warranties and indemnities. So in your reps and warranties, essentially, reps and warranties in a very layman language means something which is a statement of fact. So something that you have indicated to the buyer that my company is about XYZ things. So this is my manufacturing facility, or this is my IT infrastructure, this is my intellectual property, this is what my sales have been. Everything that you tell the buyer in the process of a due diligence is something that the buyer would expect you to give it in form of a representation or in form of a warranty in the document. So I think one also needs to be very careful about what are the kind of points that are being told at the time of the diligence, because that is what you are going to have to later in the definitive agreement mention, that these statements are true as on the date I'm signing the document, and as on the date we close the documents. And lastly, related to that is indemnities. I think probably a little later I can touch upon that, what the indemnities are and what are the kind of buckets which are there, because I can see some of the audience questions also being there. Pushkar, Dolos, do you want to take that first?
We can continue. I thought we could continue, and then we can probably, once you're done with the segment, or are you done with the structure segment, or you want to
I
dive in?
just have two more points to finish on that, on the
Yeah,
structures.
please carry on.
Right. Right. So then again on the structure, basically linked to the reps and warranties is the indemnities. In indemnities is essentially, let's say, for example, giving you a smaller example, you say that there is no litigation or dispute in relation to my company as on the date I'm transferring the company to the buyer. And that is a statement of fact that you have made in your definitive agreements. After the investor has invested into your company, or rather bought your company out, they realize that there was actually a litigation that you didn't disclose about. So they are going to come back to you by asking for an indemnity, which means that you in a way lied to us, or you did not disclose the true facts to us, because of which we have become out of pocket, and it is pertaining to the time when you were a 100% shareholder of this company. Therefore now you indemnify me, which means now you make me good. So in indemnities, there are various buckets that you can put in, that which are the caps for a business kind of warranty, that anything in relation to the business, or what are the kind of indemnities that you can give if the title to shares is not right. So there are various buckets which are there even in indemnities. And the last thing that also becomes important in a 100% sale is the non-compete provisions. So for something about a non-compete provision is that, once you hand over the business to the buyer would not want that you are doing the same business, right after selling your own business to the buyer. So I think non-compete provisions do become important, and the founders also need to think about the fact that, after the sale of the business, what is it that I'm going to do? Do I want to do something similar? Which means then I should ask for a carve out from the indemnity at the time I'm doing the definitive agreements. So I think non-compete also becomes, and what is the period of the non-compete? So for example, I can't do the same business, let's say for a period of 18 months or 2 years. Vis-a-vis, can I not do the business for a period of 5 years? So I think that also becomes a very strong negotiation point at the time you're doing the transaction documents.
All right, that's awesome. So a lot of it went above my head, to be honest. But we have an audience question, which is based from Pallav. Pushkar, if you can show the question on the screen. Hey, thanks, man. So Pallav is asking, out of your experience, how often do you see term sheets get revised post due diligence? Right. I think Pushkar, you can also weigh in on this question. You can probably you must have seen the initial stages of the transaction, right? And of course, Prakriti can add more value into it. Do you
Right.
want to attempt it, Pushkar?
So my experience has been not very often, unless something drastically goes wrong. But Prakriti can tell us, like, in what cases buyers or funds might like to revise term sheet. Like,
Right.
something on those lines would be really helpful.
Right. So thanks for the question, Pallav. So essentially, when we say that, how often do the term sheets get revised post due diligence? So by revision, there could be. It's not necessary that the entire valuation get revised. Maybe, if a buyer has offered you a multiple of, let's say, X over the revenues, for example, the buyer is probably even still able to give you that same multiple. They will probably not revise the multiple that they are offering to you. But from the books of account or from the financials, if they identified that, there are XYZ things which are not fine, or we believe that this requires a value reduction, that is one way of doing that. At the value reduction itself, they will deduct the value from the purchase consideration. Or if they believe that this is something which is contingent, it may happen or may not happen. So let's say, for example, a tax litigation. If you believe there is a tax litigation that is there, and the buyer is of the view that this either could happen or could not happen, they will probably not do a value deduction immediately. They might just say that, why don't we take a indemnity on this aspect? If at all this tax litigation formulates into a actual outflow from the company, then you make me good for that. But otherwise, I'm not reducing the valuation that happens. Another thing that I've seen changing sometimes from a term sheet to due diligence stage is that sometime it happens that, after doing the diligence of the company, the buyer, let's say, believes that initially it was a 100% sale transaction, but now I want to do a tranched buyout, because let's say I want to take 80-90% upfront, but I want you to continue for a bit to do a proper transitioning to me. So that could also be the case where you believe, or where the investor believes that a transition period would help out in actually running the business for themselves. So that is primarily, things that we see changes from a term sheet after the diligence.
So I think that was a really good answer. So Prakriti, you spoke about a lot of things. So there are three things I would like to touch a bit more in detail and
Right.
ask your opinion. So one is CPs. So
Right.
maybe like then the second would be when you say non-compete. So then
Right.
why do buyers insist on non-compete? What's the advantage? How
Right.
do they enforce it? And then third would be also when you said I can't remember the third point, but yeah, right. Then the third point when you said like it can also take a lot of time to do the entire diligence. So would
Right.
you like to just tell us about? And we also have some audience questions.
Right. Right.
Maybe if you can touch upon these three issues first.
Right. I think I can see a question from Jay. How can a company prep well for a swift diligence process from its early days?
Do you want
So
to
I,
answer this one first? This
sorry.
question from there.
Right. So, but I think typically, Jay, in a due diligence process, I think there are 5-7 buckets that get captured, as I was mentioning earlier. Corporate secretarial, which is basically all your minutes, etc., and filings with the ROC that gets covered. Your financing facilities, which is your loans, etc., that you would have obtained. Your contracts that you may have, let's say customer contracts or vendor contracts, supplier contracts, that gets covered as part of a legal diligence. Then your HR issues, basically, whatever you are paying to your employees, whatever you're required under law to pay, and whatever are the social security benefits you're supposed to give to them, like a provident fund, ESI, etc. Then your intellectual property, if it is a business that requires a trademark registration, intellectual property registration, then that is something that they're going to look at. Then your regulatory section, basically about the licenses that you require to run your business. So for, let's say, for an IT company, it may not be there may not be too many licenses, but for a manufacturing setup, you would have things under Factories Act, your Air Act, Water Act. So there are various licenses that are applicable that are to be obtained from the government. So they would look at that. And then your insurances that you take in the ordinary course of business. And lastly, the litigations, as to what are the litigations that the company is under. Let's say, are there any customer disputes, or are there any recovery disputes? What are the kind of disputes? So I think what the company should do is that keep these buckets into mind and populate the documents in the data room accordingly. Or they should just be aware that these are the things that any investor is going to look at. So maintain the record keeping, or do the record keeping in a proper manner, so that if need be for a due diligence, you can readily pull out the documents, and make it available to any investor for a diligence.
Awesome. So you want to continue, Pushkar, your thoughts on the three questions?
Right.
No, no,
Go ahead,
sorry,
Pushkar.
just going back to the question. So Dolores and I, we always discuss about this non-compete, because
Right.
what we have seen is all buyers insist on non-compete, and
That's
then
right.
the duration also varies. Sometimes it's 3 years, sometimes it's
Correct.
5 years.
Correct.
So of course we understand why do buyers insist on non-compete, but what is your take on that? How long is the duration, typical duration, and
Right.
how do buyers enforce that? That would be lovely, like some insights on that.
Right. So, Pushkar, non-compete, I mean, as the name itself suggests, that, that you, in case a buyer has invested or has bought your business from you and has paid you a hefty premium, because typically, in most of the deals, there is a XYZ multiple that you're getting over the revenues, or there is a multiple that you're getting over your profits, etc. Right? So the buyer is paying you a premium over what you are earning from your business. They are paying a particular premium over that, and they don't want a situation that today you've sold your D2C brand to them, and immediately the next day you're going to build the same brands, or a brand in a similar segment. So because they are paying you a premium for that, so it's logical for them to ask for a particular non-compete, as to that you're not going to enter into the same business, because you have run the business for so long, which means that the entire supplier and the vendor and the customer network. It's very easy for you to sell the brand today and immediately tell your people that oh, tomorrow I'm going to start a new brand, which means that there's no advantage for the buyer to pay you a premium for your business, right? Because then it's not something that any buyer would want to do. So that's the reason they insist on a non-compete clause. The period for non-compete is typically starting from anywhere from a 12-month period to a 3-year period, which is what we considerable reasonable, because even the courts in India don't see non-compete very favorably, because it's something that's stopping you to do the business. So only reasonable restriction on a non-compete is something that is enforceable in India. The typical period, the minimum period that we see is 12 to 18 months is what we see as a minimum period, and the maximum period that we advise the clients to take is a 3-year period. So I think that is the point, where I think that is something that is typically acceptable to most of the investors, anything between 12 to 18 months to about 3 years.
So we have another question. Meanwhile, uh, from Omkar over here, Pushkar, if you can show it on the screen. Is it possible that instead of revising the term sheet, you try and add a clause in the definitive agreements?
Yeah, absolutely, Omkar. By revising the term sheet, sorry if I gave the wrong impression earlier. What I meant was that revising the terms of the term sheet. So you will not revise the term sheet per se. Typically, term sheet, when it gets signed, there will not be an amendment to the term sheet. What will happen is that, whatever is the deviation from the term sheet will get captured as part of the definitive agreements. So if the term sheet said XYZ, and if you believe there is an additional point that needs to be get captured post the diligence or post the discussion between the parties, you can revise it directly in the definitive agreements. So the term sheet revision or the term sheet amendment is not that common to see.
Awesome. Thanks, Prakriti. I hope, Ankar, that has been addressed, right? We also have a question from, Brijesh, little before, it happened a little bit while back. So, Pushi, but I have to scroll down, right? Are there any items you should consider while incorporating or building a D2C brand that may save the hassle once you are ready for a sale? I guess a part of it has been covered in your answer earlier to Jay, if I'm not wrong. Isn't it, Prakriti, you want to add anything more into
Right.
that?
Right. I think while incorporating or building a brand, I think as something that I mentioned earlier, right? You need to have your paperwork in place, because many a time what happens is that when we are representing the investors, and I've done a lot of work, representing the investors, and what we see is that, the companies have not maintained their records properly. For example, the contracts are not in place. They would say that these are verbal arrangements. हमने PO issue कर दिया और उससे काम हो गया हमारा, right? And then what the founders need to appreciate is that while it's easy for a founder to say that my business is running on the basis of the relationship that I've developed with my distributor, my supplier, and my customers, right? But you also need to keep in mind the fact that when an investor steps into your shoes, they do not have the same relationship, which means that your relationship may be great, but the point is that how do you pass on that relationship to your investor when there is no contract in place? So I think from the very beginning, when you're building a brand or incorporating the company, it's very important to have the right advisors in place, like a chartered accountant, a lawyer, a company secretary, to have the right paperwork. Because if the idea is to sell the business, then the relationships will not be able to get passed on. The personal rapport will not get passed on to an investor. What gets passed on to an investor is actually the documentation that you have done and the binding agreements that you have done.
Another point which I think Pushkar always stresses upon is also the MIS and the data, which sales
Absolutely.
data. Because after all, the valuation of the company is dependent on the profit and the money you make, right? So that also has to be very structured and very, very, bulletproof or foolproof, right? So that's one thing which I always hear from Pushkar a lot. We are getting a lot of questions again, so we'll try to tackle as many questions as possible. We are also running out of time, right? So Prakriti, Priya is asking a very interesting question. Is the non-competing agreement, is it geography specific, or like for example, you sell a product brand in India, and then in US, can you start the same company again?
Right. So, Priya, good question. Essentially, yes, the non-compete provision can be geography specific, but I think that is something that you negotiate at the time you do the transaction, right? Typically, a buyer would not really want to include a geography because they know, I mean, that you would stop the. Specifically, this happens a lot in the IT or a SaaS business, right? That you've just started the business and you've done it in India, and you're doing it in India, and you sell the business, and then you go and immediately start it, let's say, in the US, because a lot of SaaS businesses have customers in the US, and you immediately start the business in the US. So typically it will be completely dependent on that what is the geography you have agreed to at the time of negotiating the agreement. So negotiating a geography becomes important. If you have said it's worldwide, again, most buyers are okay to restrict that business to India or any other country where they are operational. So let's say the buyer of the brand, let's say, has business in India and China, for example. So they would say, at least in the geographies I am present, don't do the same business, but I'm okay for you to, let's say, start the business in the US. So in that particular case, the geography will be completely dependent on what you've negotiated with the buyer.
Just a follow-up question. For a D2C brand, I guess geography makes sense, right? If you're selling a D2C brand in India,
Correct.
right? So it is usually in Indian marketplaces or in Indian economy that
Absolutely.
that product is sold, right? So I guess geography, I don't think the buyer should have a problem with it, if I'm not wrong, right? Again,
That's right.
of course.
That's right.
Right, right. So we have more questions coming in. Pushkar, you want to ask the second question because you're on the line as well, right? You had three questions. Or you want
No,
to
yeah.
follow? Continue.
Before we go to more audience questions, there are two things I really want to ask Prakriti. One is what happens once the diligence is over? Because we always hear about these terms like SPA, SHA.
Correct.
Now, if you
Correct.
can tell us a bit about what exactly are they? And then
Right.
also the point you mentioned earlier, CPs. So
Right.
are CPs part of SPA? Are they part of SHA?
I'll
How does
I'll
the
touch upon that.
timeline work?
Right, right. So, Pushkar, as you rightly said, that once the diligence is over, the typical documents. See, there could be various documents that could be done based on the transaction structure. But let me just simplify it by talking about SPA and the SHA. SPA means a share purchase agreement, which means that this is the document under which the shares of the company are being bought. I mean, in a very simple plain English, it's the document under which the consideration flows to you and you deliver the shares. So that's what a share purchase agreement is about. The share purchase agreement, the key contours of that is: one is the sale of the shares, second is the receipt of the consideration, third is the CP, which is the condition precedent, that which are the conditions that you need to fulfill prior to selling your brand or selling your business to the buyer. Then comes your the closing actions, or we call the completion actions, which means that what are the action that needs to be undertaken at the time the shares are being delivered and money is being transferred. So you need to have, let's say, a board meeting where the shares are, the transfer of the shares is getting recorded. Prior to that, you need to have your stamping of the share certificates, etc., done, the share transfers to be filled. So there are various things that get covered as part of the CP and the closing actions. Other than this, you will have your reps and warranties and indemnities, which I already spoke about. That reps and warranties is the statement of fact, and indemnities is what you're indemnifying the buyer if the reps and warranties appear to be untrue. So, and then your non-compete provision. This is what typically gets contained as part of the SPA. SHA will be executed only if you're continuing to be a shareholder in the company post the acquisition. So, for example, not every deal is structured as a 100% buyout. There could be a scenario where you have a 80% buyout or a 90% buyout, or there could be a scenario where you have, let's say, the investor taking in only 51% for now, and you'll continue as a 49%. So, shareholders agreement governs the inter se rights between the shareholders. So, for example, that from the time the investor comes into the company to the time either the investor exits or you exit the company, till that time you're both a shareholder of the company. And how are all the governance of the shares, or how the governance of the company is going to happen, is something that gets covered as part of the shareholders agreement. There could be various things about what a board composition would be, how would the voting be done, are there going to be some reserve matter or affirmative matters, without, I mean, those are special matters of the company which can't be done without the approval of, let's say, the investor or the founders. Then there are share transfer restrictions, which we speak about, let's say, a ROFO, or a tag along or a drag along, which is about how the shares of each other is dealt with, or if you want to transfer to a third party, what happens in that case. So those are the kind of things. Basically, I think there is a question also that as an investor, which clause is mostly chosen between ROFR and a ROFO. So let me speak about this. So ROFR is a right of first refusal, which means that if you have an offer from a third party for, let's say, 100 rupees, you will go back to your investor or whoever is the ROFR holder. You will go back to them and tell them that this is the price I have got. Do you want to match this price and buy my shares at this price, or should I go and sell to a third party? So investor in that particular case will have the right to match the price that is being offered to you by a third party outside purchaser. In a ROFO, which is the right of first offer, the investor can have the right of making the first offer to you, which means that if you want to sell the shares of the company, you will first go to your investor and tell them that I want to sell the shares of the company. What is the offer you can give to me? So basically, you do a price discovery from the investor itself, and then you ask the investor for a ROFO. They will give you the price, and then either you can sell it in the market above the price quoted by your investor, or you will have to you can decide to sell to your investor itself. So when the restriction is on the founder, the ROFR, which is a right of first refusal, is more friendly for the investor, because investor will be like that, why should I do a price discovery for you? You get the price from the market, I'll see if I want to match it. But if at all the investor has to give certain this kind of provisions to the promoter, the investor would always prefer a ROFO, because then in that particular case there is no hindrance on the sale of their shares if they have already negotiated with the third party.
So I think Rofer is also friendly for the seller as well, right? As is the brand owner, the founder, right? In a way, because you get to know what is the market price first before going back to the investor, right?
It is in that sense, because for a promoter, they may want to do a price discovery from the market to get the best value for themselves. When it comes to a promoter, they are okay with granting
Mhm.
a ROFR, because they can discover the price from a market and then go back to the investor and say that this is what I'm getting from the market. Now you either buy me at this, or I'm going to sell to the third party.
Right.
And if the similar restriction is, as I said, the similar restriction, if the investor has to give, firstly, investors never usually agree on giving a ROFR. But if they have to choose between a ROFR and ROFO, they would prefer to do a ROFO, because in case of ROFR, they believe that, if I get the price from a third party, and my if my promoter can match it, then the third party will not really give me a genuine price, because they know that there is a ROFR which is there on the share. So that's not very favorably seen from that perspective.
Okay, interesting. What's your third
One
question is
question
before we?
on ROFO and ROFO, Prakriti. So
Right.
when you are representing founders in startups, what do you advise them? Do you advise them to go for ROFO, and say if investor is giving them investor insists on a ROFO, how do you convince them that hey, ROFO is a better structure, we can't do ROFO? Because that this we have seen in a lot of term sheets, especially in the venture capital side, when a VC would always insist on a ROFO, and then the founders or startups lawyers come and say, hey, like these are the advantages of ROFO, this why ROFO is better, or why vice versa. So how do you
Right.
advise startups on this?
So, Pushkar, to be honest, there's no set rule as to which is better. I think it completely also depends upon, what the particular founder. If I'm speaking from a founder side, what particularly a founder wants is also very important in this scenario. So, see, for example, if an investor is already invested into your company, to be honest, they are the best buyer of your shares, right? Because they already know about your company. They are not going to do any diligence. You have a great rapport with them. It's always better to sell it, let's say, to the investor, and investor will also be more keen on buying those shares, right? In that particular case, you may want to keep a ROFO, because you would say that आप ही मुझे offer दे दो. I will see if that offer is to my liking. I don't want to go to the market. I don't want to do a price discovery. I'm happy to sell the shares to you if you're giving me a good price, right? So sometimes the founders want to save the hassle of going to market and going through the entire due diligence process again, etc., etc., because that becomes cumbersome. So in that particular case, a founder would be okay to do that, right? But in some cases, the founder might believe that no, I don't think my investor is going to give me a great price. I'm going to do a price discovery from the market. I'm going to ask the market that, what is the price of my share? And then I will give the option to the investor to match it. So I think it is completely dependent on what the founder believes is right for his business, depending on the kind of investor which is there.
Okay, brilliant. Dulos, do you have anything to? Do you want to ask anything on this?
Managed question, right? In this ROFO and ROFO structure, right? If if it's a ROFO structure and the founder goes to the investor, asks for pricing, right? And investor makes an offer, he doesn't like it, he can go to the market and do a price discovery or find a better investment, a better buyer, right?
Right.
Or if he doesn't find a better buyer, he can always have this offer on the table, right? So,
Absolutely.
uh,
Absolutely.
so
That's the whole
how
idea of
does
it.
right? So I don't see why exactly it matters much. I mean, it's just like either ways, it's almost same. I mean, in a laymanish way, I'm seeing that either ways, it's almost the same thing, right? So how does it? Why is this close there?
No, so I think, Dulos, what happens is that, if you take the offer from your investor and then you go to the market, I think obviously it works for you that, you say that my investor is offering me 100 rupees, and can you offer me anything more than that, right? So I think that absolutely works fine. But in case of a ROFR, as I was earlier saying, that ROFR always reduces the marketability of the shares, because when you go to the market and you tell the prospective purchaser there is a ROFR on my shares, the prospective purchaser would be like that, अगर मैंने आपको 100 रुपया दिया तो आपका इन्वेस्टर जाके आपको 110 दे देगा, and then my time and effort gets wasted. So why should I discover the price for you? So ROFR,
In offer.
yeah, ROFR conceptually obviously reduces the marketability of the shares. That is a given fact.
Okay. All right. Thank you for clearing that. Pushkar, over to you. You want to have ask the third question, or shall we go to the audience question?
So there is one really interesting audience question, but I am saving it for the last. So
Okay.
Prakriti, I just want to touch on one thing, because you have spoken a lot about indemnities and indemnifying.
Right, right,
This is not a really, this is not a common word we use in our daily lives.
right,
So
right,
most of us don't even know what does indemnifying mean.
right,
So can
right.
you please explain that in plain English, like what is indemnity? What do you mean by indemnifying? And also maybe one example, like a clause of where buyers insist on indemnities and their lawyers.
Right. So I think indemnity, in a very plain, simple English, means is making good, right? Making good somebody for the loss that has happened because of you. So, for example, I at the time, as a seller of a brand, I have said that I don't. And I always take the example of litigation because it's very easier to relate to that. I, as a buyer, have said that I don't have any litigation in the company, and later you realize. On today, let's say on 9th of February, I'm selling my business. I say as on 9th of February, there is no litigation in my company. There is no dispute in relation to my company. The buyer invested in a company on the 9th of February. Let's say on 31st March, the buyer realizes that there was actually a recovery suit that was filed against your company where your company failed to make certain payment, let's say to one of the vendors. Just to take an example, that 100 rupees has been claimed by the vendor. You did not pay that and you did not even disclose about it to the investor. And 31st March, let's say a court order gets passed where the company is liable to pay 100 rupees to that vendor, right? So this can happen that 9th February you said that there was no litigation, but 31st March there was an existing litigation for which a court order gets passed that the company is liable to pay that 100 bucks. Now investor would be like that this was a past litigation, it was an amount that you ought to have paid, or I should have reduced it from your purchase consideration, so why should I bear it, especially when you did not even tell me about it. In that particular case you will be liable to pay that 100 rupees back to the company, or so to say to the investor, because that is something that you lied about or you misrepresented about or you did not disclose about it, and you make them good for the loss they have incurred for the period you were a shareholder.
Okay, so just to carry forward this point, investors or buyers look at indemnities as a fail-safe for insurance policies. In
Right.
case the seller, in case the seller is hiding something.
Fair,
What?
exactly. I think you've hit the nail on the head. So it is like an insurance, and in fact, there is actually reps and warranties insurance that is available now in the market. It is being There is a reps and warranties insurance that is it's readily being used in most of the U.S. transactions that we see in most other jurisdictions. It's a very prominent product in the market, and now it has obviously entered India also, and there are insurance companies that are providing a reps and warranties insurance also. So we have seen in, I mean, it, to be honest, it does not really is common to see that in a startup kind of a deal. These are more for advanced companies where reps and warranties insurance is taken, more like the larger businesses, and not really so much for the startups, where there is a product of a reps and warranties insurance that you will give certain set of warranties to the insurance provider. You pay a particular premium, and if at all a claim comes from there, then instead of asking back the money from the founder, you are actually going to claim it from the insurance. So as you rightly said, it's more like an insurance, but to be honest, in case you've really not disclosed the fact correctly, that's when you become liable to pay.
Right. So folks, we have what 3 more minutes, 4 minutes, right? I guess to reach our timeline of 45 minutes. Prakriti, do you have time till 12, or you want to end up a little earlier?
No, I'm okay. We can speak for 5-10 minutes. Not a
All right.
problem.
So, Pushkar, you want to ask that interesting question you've been? Oh, right. Awesome. Is this an interesting question you wanted to ask?
So that question is, I'm just saving it for the last, but this is also an interesting question, Prakriti. Your thoughts?
Yes. So, does a tag along and a drag along clause exist simultaneously, or only one can exist? No, it can exist simultaneously. A tag along and a drag along. So, to explain to you what a tag along means is tag along means, and it can be either ways, right? A promoter can offer a tag along to the investor, or an investor can offer a tag along. So, tag along really means that if the party is selling the shares, the person who has the tag along right can just co-sale with them. So, for example, if I have as an investor, if I have a tag along on the shares of the promoter, so if the promoter decides to sell the shares of the company, the investor will say that I will tag along with you because you are leaving the company, or let's say you are selling a portion of the company and getting liquidity out of that. I also want to participate. It's more like a co-sale right that is available to the investor or founder depending on what gets negotiated as part of the transaction documents. And in tag there are two concepts: one is a full tag and one is a proportionate tag. Full tag means obviously that you can sell your entire shareholding in the company, and proportionate tag means that whatever is the particular investor or the founder selling, then you proportionately sell a part of that. So that is a tag along. A drag along is something typically that is a right that investors keep in a particular scenario where when a venture capital investor invests in you, or a private equity investor invest in you, right? They would say that I want my exit, let's say in a period of 3 to 4 years or 5 years. I want my exit, and if that exit has not happened, they might say that fine, if I am getting the offer, I can drag you along with me, which means that let's say the investor is holding 51% of the company and you are holding 49%. The investor might like say that if I'm getting the buyer for 100% shares of the company, I will sell my 51%, and on the same terms and condition, I'm going to drag you out, which means that you will be liable to sell your entire shareholding in the company along with me at the same terms. So the tag and drag, to answer your question, can exist simultaneously, and more often than not, they always do exist simultaneously.
Okay, brilliant. Because we have also seen all term sheets, tag along and drag along, right? And
Right.
I think you explained it beautifully. Now, we still have maybe 5 minutes, so just two final questions. One is quite similar to tag along and drag along, right? So maybe you can just take this one. This is from Pawan.
Right. Is anti-dilution clause normal in Indian VC terms? If yes, will it be full ratio or a broad-based weighted average? So yes, Pawan, it is common in a VC term sheet or a private equity term sheet. To explain to the audience what an anti-dilution means is that let's say the valuation, the pre-money or the post-money valuation of the company is let's say 100 rupees, right? At a 100 rupee valuation, you have got an investor. The investor would expect that the valuation of the company will now obviously multiply, right? So the next round of funding that you're going to do will not at least be below 100. So in that particular case, if the VC invested at a 100 rupee valuation, they would expect that next round of valuation is above 100. So an anti-dilution kicks in where in case you are doing a future round of fundraise, but instead of a 100 rupee valuation at which your existing investor invested, you're actually going for a valuation of 90 rupees. So in that particular case, the VC investor would say that your investment really your valuation of the company has really gone down, which means that I want to be made good, because had I invested 90 rupee valuation, I would have got more shares in your company, which means that I invested a few let's say a year back or a few months back. I invested at a 100 rupee valuation, and now I want to be I want it to be in a manner that my 100 rupees or whatever money I had invested into the company is depictive of the current valuation of the company, which is at 90 rupee. So which means that a full ratio would mean that you give them you just do a math that if they had invested X amount at 100 rupee, what does it translate into, versus if they had invested it at a 90 rupee valuation, what does that translate into, and you give them an extra number of shares on that basis. In a weighted average, there is typically a formula that is agreed, and weighted average typically comes into picture when there are multiple round of investors, like you've raised a pre-seed, you've raised a seed round, a series A, series B. So then in that case, you can do like a weighted average, then you end up giving lesser number of extra shares to the investor. So I think both are commonly seen, but typically when you're doing various series, weighted average is now something that is being seen more commonly.
That's on a startup perspective, not a D2C brand perspective, if I'm not wrong, right?
Yes,
For a
yes,
D2C brand,
that's more on
it's kind
startup
of
when they're doing venture capital fundraise, not a D2C.
right, right, right. So we also have another question on the same lines, if I'm not wrong, Pushkar. I wanted to understand if preemptive rights and anti-dilution rights are simultaneous or independent. Are you
Yeah,
able to see the question?
yeah, I can see the question. I don't know how much time we have, so
Yeah.
couple of things I just want to discuss before we
Right.
wrap up. So what Prakriti explained is called a down round,
That's right.
where you raise valuation say at a $10 million pre-money. Now maybe all of a sudden your revenue comes down, or maybe the market changes, and now you're doing the next round at 8 million. Now the investor who invested at 10 million is at a loss because the new investor is coming in at 8 million. So that's where the anti-dilution clause kicks in. Now, full ratchet and weighted average are two ways to calculate how much additional share the existing investor will get. Full ratchet is more investor friendly, weighted average is more founder friendly. Now, both are very common, and that's where a good lawyer comes in. Like what we have seen is all good startups, they tie up with a good law firm because most founders don't really understand that. Like there's so much technical jargon that even people like us who work with startups day in day out also don't understand so much. So that's why we always ask startups to find a good law firm to protect their interest. Now there is one question I just want to end it because Pawan asked it long time ago. And see, as a startup, if you're hiring a good lawyer, the idea is to protect your interest because the buyer or the VC will of course have a good lawyer. So you should also have someone in your team who understands legal technicalities, what are the different clauses, what are important, what is less important. You just can't negotiate on everything. You need to pick your battles. And that's where this question comes in. And I would prefer, like, if Prakriti can give give her views on this, what has been her experience.
Right. In your experience, what are the three rights or clauses that promoter, in case of complete sale and minority dilution from VC, both are most negotiated between the two parties? I think Pavan. I think three things. I mean, there is slightly the difference between what gets negotiated in case of a complete sale and what gets negotiated in case of a minority dilution. So, in case of a complete sale, because you are exiting the company and there is no, for example, all of this anti-dilution, ROFO, tag, drag, none of this comes into picture because you're exiting the company. So, in that particular case, I think the three things that you would keep in mind is, one is obviously what is the valuation that you're getting, what is the price that you're getting, is there any way that the investor can reduce the price, or there is anything about, let's say, linked to a working capital adjustment or a net debt adjustment. So that is one thing that you look for. The second thing you look for is the kind of reps, warranties, and indemnities here that you're giving, because once you've got the money, returning any penny out of that is not really something that any founders want. So reps and warranties is the second thing that is important, and third is the non-compete, as I had mentioned earlier. In case of a complete sale, non-compete becomes very, very important. So these are three things from the perspective of the complete sale. In case of a VC, because you are just raising the money for the growth of the company, in case of a VC investment, and you are going to have future round of fundraisers, again, what becomes important is what is the kind of reserve matter that the VCs have. That can they stop the fundraise, can they block the fundraise, or can they in a way block the any kind of development of the company. So what are the kind of reserve matters you're giving to them becomes important. Second is, again, what is the kind of anti-dilution that you're offering to them. I mean, again, as Pushkar was rightly mentioning, that in case of a down round, which might happen many a times, that if the business is not going the way we had anticipated it to be. So what is the kind of anti-dilution, again, that you are negotiating with them? And then your typical transfer provision, that ROFO, tag, drag, what are the exit clauses in relation to VCs. That becomes important, that what are the scenarios, what is the exit horizon that you see for the VCs, what is the obligation of the company or the founders to provide the exit to them. If that does not happen, then in that case, is a drag along that is going to happen, and that you means that you'll be dragged out of your own business. So I think those transfer provisions become very important for negotiating in a VCD.
Pushkar, we lost Pushkar, I guess. Oh, you're here.
Still here. So many thanks, Prakriti. This has been immensely helpful. I think we are almost.
One last question, I think, on the screen.
What question?
We have many questions which you missed in between, actually, to be honest. But I guess
because
Prakriti, in the interest of time, we also need a couple of minutes to thank you,
Right.
wholeheartedly, right? I mean,
is there any question you want to answer, Prakriti? Which one?
No, I think I could just see one on the top about preemptive rights and anti-dilution. I'll take maybe 30 seconds on this. So preemptive rights is only about that, where you are doing a fundraise in the company, then the investor has the right to participate in that. So that's the preemptive right, that, if you want to do a fundraise, you also give an offer to your investor to participate in that. That is a preemptive right. And anti-dilution is something that we already explained about, that, in case of a down round, what happens. So that's the difference between preemptive and anti-dilution, and they always coexist.
that is from Radhika. I hope, Radhika, the question was addressed. So, Pushkar, you want to wrap it up, or shall I say a few words thanking?
No, of course, I would give you the chance, Julos.
Also, thank you very much. I thought you were
No, but
holding the
just
mic.
1 minute before you wrap it up. So my point was, it has been immensely helpful. So maybe next time we can do one more session exclusively on ST and SHA.
Fair
Because we didn't get time to touch on those documents. So,
Right.
I think we should do multiple sessions, Pushkar. I mean, as a layman, right? You are daily engrossed in the transactional business, right? Of selling and merging and acquisition and all the stuff, right? And Prakriti, of course, is expert in it. You guys were talking like 2 steps above most people over here. I'm pretty sure we are like about 80, 90 people viewing it at any point of time, right? So, and as a layman, I'm the layman voice right over here. So, uh, we should have like probably a dozen, a baker's dozen of sessions over here, and probably zoom in a bit more. I guess we took a very wide topic rather than zooming into one segment, particular, maybe just the jargons alone, or explaining the concepts or the process, probably like that. We might want to split it out, but probably it was like super useful, and probably this is the only session which I'll go back and listen again probably a couple of times, because as I told you, it's a lot of jargons inside it which I haven't come across, or which I didn't completely understand. thank you very much for explaining the concepts really beautifully. It's amazing. I mean, I guess this 45 minutes was really worth it for me today. Yeah. So, and of course, I'll ping you on LinkedIn again and again. And in any case, if you folks want to see this again, LinkedIn Live will be there on Pushkar's feed. This is posted from Pushkar's profile, so you'll find on the Pushkar's feed, of course. Otherwise, we are there on the YouTube channel. You can go to the YouTube channel. This is recorded and will be published over there, without much edits, right? So you can always go back and listen to it at your time, at your leisure. Yeah, that's it. Thank you very much for attending. Pushkar, anything else to add on?
Thanks,
So
Dulos.
I think we are getting some really good comments. So Prakriti, we must do a session 2 in which
Yeah.
maybe we can
Would
go
love
more
to.
specific into a couple of topics.
I think this was really the tip of the iceberg. I mean, and we tried to cover a lot of topics. I mean, due diligence, I can speak about it all day. SPA, SHA, I mean, I'll probably take 2 days to finish about that. So I think, yeah, there's a diverse topic we did that. And I think depending on the feedback of the people who we are trying to help, I think we can certainly do another session.
Awesome.
All right.
Awesome.
Brilliant then.
Awesome. Thanks
Thanks,
for joining me,
everyone.
folks. We'll try to address your questions probably in the comments later on. Thank you very much.
All
Thanks,
right.
thanks,
Bye.
Pushkar. Thanks, Dulos. Bye bye.